Yes.
Item number 1.
May it please your lordship.
Ready for hearing?
My Lord, I have concluded my arguments yesterday, my Lord. Motion matter.
Okay. Short Passover, we are coming back. Short Passover,
Lord,
we are coming back.
Lordship.
Item number 2.
May it please your lordship. My lord, as per your lordship direction, we have taken steps, my lord, and
Lord, I'm entering appearance for respondents number 1, 2, and 3, private respondents.
so condonation of delay of 44 days, my lord.
My lord, if I may, I'm appearing on behalf of the state lordship. Lordship, this is an appeal, my lord. However, on going through the records, the state was never a party at the first round of litigation, that is before the learned single bench lordship. And here also we are made pro forma respondents, but there's no prayer against us, lordship.
There is no prayer because one FIR has been
And
registered.
further, the petitioner, the appellant has not craved leave of this honorable court to implead us as necessary parties.
You are not a party in
No,
the
lordship. At the first round of litigation, we were not parties,
All
lordship.
right. Please take your seat. Yes.
Lordship, much obliged.
Who's for the appellant?
Lord, I'm entering
I'm
appearance.
attending for that.
I'm entering appearance for one.
The other respondents have been served.
My Lord, there's a number 4, my Lord. Number 4 is not.
1 to 3, they have been served. Number 4, my lord, it is yet to be served because we approach post office, my lord. It is yet to be delivered so far as respondent number 4 is concerned, my lord.
Yes, please take down. Service on the respondent number 4 has not been effected. Let such service be effected immediately and an affidavit of service stroke service report be filed before the next returnable date. Paragraph. Mrs. N.G. Shaila, learned senior advocate appearing for the state, submits that her client was not a party before the learned trial judge and has been impleaded in the appeal without the leave of this court. Full stop. We take note of the submission, full stop. It is justified. Full stop. You are now respondent number?
5, lordship.
Hi.
Let respondent number 5 be struck off from the cause title of the appeal. Full stop. Leave is reserved to the appellant to take appropriate steps to implead the state in this appeal if such right is available to her. All right?
Lordship, just a small note, my lord. I'm a senior government advocate, lordship, not a senior advocate, lordship.
We have said so. Senior
Lordship,
government,
lordship.
senior government advocate.
Apply, lordship.
Lord, I'll file a short reply to the application for condonation of delay.
Let the service be complete,
Madam.
then directions will be made.
My Lord,
Much better.
deep.
Deeply obliged, my lord.
Item number 3 to 13.
Ready for hearing?
Lordship is, are you to?
Yes, I will.
Ready?
Yes, sir.
Please tell us.
Because you are having.
Yes,
half,
sir.
no?
You are ready?
Yes, sir.
All right. Pass over. This will be the second matter. All 3 to 13 are connected.
Collected, your
Yes,
Lordship.
All right. Pass over. Please make a second call.
Second call, item number 1.
Promotion due, promotion effected, and you want a notional
A retrospective
Yes.
promotion, your Lordship.
Yes, my lord.
retrospective effect, right?
Yes, my lord.
Lord,
Because the
When the
delay
promotion became due,
in 2014. my lord. So a delay of 5 years, my lord. The delay was on account of they were waiting for regularization of certain persons, my lord, 9 in number, above in the gradation list, who were ad hoc employees.
what happened on 11th November 2019?
11th November, the DPP, my lord, sat, my lord, and a recommendation was made on 11th of November 2000 or 2019, my lord. And the DPC recommended that in view of
Promotion effected 3rd March 2020
2020, my lord.
Lordship, yes.
from LDA to UDA.
Yes, my lord.
What has the learned trial judge ruled?
My lord,
Lordship will kindly come to
the
page
trial
85.
judge has come to finding that it is not a matter of right. It is only when there's malafide. Now, my case is malafide. The delay cause was intentional. They were waiting for regularization of ad hoc employees who were on temporary basis, my lord, which, my lord, had they been regularized, we would have not been able to get a promotion, though we are regular employees, my lord. So it is a thin line of, my lord, delay, intentional delay, my lord,
Of 5 years.
of 5 years, my lord.
So if you would have been regularized, the ad hoc employees would not have been regularized.
My lord, had the ad hoc employees been regularized, I wouldn't have got my promotion. So they were waiting for 5 years for them to get regularized. But when the delay became too inordinate, my lord, they had to hold the DPC, and then only we were regularized, or then only we were promoted.
No, what was the reason for waiting for 5 years?
They were waiting, my lord, for regularization of the number 1 to number 9. If your lordships again has page 48. Page 47 is the notice, my lord, calling for the DPC, and page 48 is the gradation list. Now the 3 appellants at serial number 10, 11 and 12 who are regular employees in the post of LDA, and number 1 to 9 are ad hoc employees, my lord. So if your lordships again now has page 77, which is the agenda and the note placed before the DPC at page 77. In the second paragraph of page 77, my lord, which starts with it may be reported. Second paragraph. It may be reported that DPC could not be held during the course of time as the office is anticipating the regularization of senior LDA staffs who are yet to be regularized by the government till date. So they were holding back the DPC because they were waiting for regularization of the ad hoc employees. Now, had they been regularized during this period of delay, we would have been deprived of promotion. So it is this intentional delay cost. It is only on this thin line. And the DPC at page 76 has recommended our promotion with effect from the date we became eligible.
No, but still they could have promoted you, leaving them out.
They have done that after 5 years in 2020. After the DPC has recommended, DPC recommended retrospective promotion. However, the government has not approved that and has given us only from the date of joining.
So what was the point in waiting? They could have regularized you and,
No, we are regular.
and in 2014
We are regular.
regularized or rather promoted you in 2014.
Yes.
And as and when the 1 to 9
Yes.
got regularized,
Yes.
they would have been promoted.
Yes. But they,
Unless the promotional posts, there was a number of posts and those posts would have been filled up by your promotion.
yes.
Otherwise, what is the logic?
They left the post vacant, for the benefit of 1 to 9, and then considered our case when
How many
only,
posts were there, promotional posts?
at the 2014, 3 posts were there, If your Lordships again has page 77, or your Lordships has page 76. This is the DPC. Second paragraph, it reads, the member secretary informed that there are 4 posts of UDA post lying vacant on being promoted of so-and-so first post with effect from 1st May 2012. So first post was vacant in 2012. Then the second post, of Srimati so-and-so with effect from 1st January 2013. The third post, with effect from 1st December 2014.
So your better case would be that only 4 posts were there.
Yes,
If you were promoted
Yes,
in 2014,
Yes,
you would have taken up 3 posts.
Yes.
And only 1 would have been vacant.
Yes.
And if these 9 persons would have been regularized later, they would have vied for only 1 post.
Yes,
So having kept them vacant,
Yes,
they have thrown open all 4 posts
Yes,
to 9 plus 3, 12 persons.
No, when the DPC sat, the 9 people were still not regularized.
No.
But because of the delay, they had to hold the DPC.
The purpose of delaying it was to throw open the 4 posts
For all.
to 13.
Yes.
Otherwise, only 1 would have been there.
Only 1.
That case would be made out.
Yes.
Anywhere.
Yes.
Where in the writ petition you have made out.
Page 5 of the paper book, paragraph 3, we say, that the petitioners through this writ petition assails the illegal and arbitrary action of the respondents.
1 minute, please. Page?
Page 5 of the paper book, This is my writ petition, para 3,
Before that, you please come to page 77.
My lord.
What is the date?
My lord, this is the note placed before the DPC on the 11th.
Dated?
It's not dated note. This is the note placed before the DPC
Undated.
on the 11th.
Yes, now you are showing us.
My lord, your lordship said, your lordship will kindly have page 5, para 3 of my writ petition, where I say that the posts were vacant and we were not considered, despite being eligible. My lord.
Para 3.
Para 3, my lord. Para 3 and then para 11 regarding the inordinate delay at page 10, my lord. And then, my lord, the affidavit of the state,
Para 10.
para 10, my lord. Or page 10, para 11.
Yes, affidavit in opposition.
Is at page 54, my lord. Before that, I'll just draw your lordship's attention to page 36. This is an office memorandum upon which I've relied. Office memorandum of 1998, which says, directs all the government directs all departments to regularly hold DPC, my lord, on a yearly basis. So in the affidavit in reply at page 54, at para 7, which is at page 55, they say because
Yes.
at para 7, which is at page 55, they say because the office was gutted in fire. And this 1998 office memorandum directing all departments to hold DPC regularly was also gutted in fire. Therefore, no delay in the holding the DPC. We are not aware of this OM. Holding DPC, my lord, is a general law, my lord, that it has to be held regularly, my lord.
Which paragraph you are showing?
Paragraph 7 at page 55, your lordship.
Yes.
So, my lord, at para 7, they say that the office was gutted with fire. Therefore, this 1998 office memorandum was also gutted, was destroyed in the fire. Therefore, my lord, they are not aware that DPC has to be held regularly, my lord. That's why the delay. This is the explanation of the delay, my lord. And at para 9, they say, my lord, it is admitted that there has been considerable delay in holding the DPC due to very genuine and unavoidable situation. That is what they say at para 9.
Yes.
And the impugned judgment is at page 81, my lord.
What reasons the learned judge has given?
Yes, my lord. If your lordships kindly have operative part is page 85, para 7. But first, I'll take your lordships to para 4 at page 84.
Yes.
In reply, Mr. So-and-so, learned government advocate, learned GA, submits that non-holding of DPC earlier was due to the fact that the office records of the department were gutted in fire, and as such, the advisory on the holding of DPC was not available. So this is the 1998 advisory that DPC has to be held regularly. However, he submits that the DPC in its meeting held on 11/11/2019 had addressed the grievance of the writ petitioners by recommending them for promotion to the next higher post and suggested that government approval be obtained with reference to the date of eligibility of the qualified candidates to UDA. Further submits that the same was not considered as the delay in holding the DPC was due to genuine and unavoidable reasons and there was no intentional, deliberate or willful delay. The learned counsel further submits that in view of the government notification 09/2003, wherein it had been clarified that regular promotion should be effected from the date on the office from the date an officer takes over charge after promotion, order had been issued accordingly after recommendation of the DPC. The learned counsel then closed his argument by submitting that the seniority cannot be claimed from a date an employee had not even been born in the cadre, and that seniority is not to be considered from the date when vacancy arose, but from the date on which appointment was made to the posts. I have heard the learned counsel for the parties. The only point for consideration in the present writ petition is the justifiability of the claim of the petitioners to promotion from a retrospective date to the promotion post of UDA. As has been noted from the arguments of the petitioners, their claim is based on only one ground, which is that on the date when they have become eligible for promotion, vacancies were available. Due to non-sitting of the DPC, the said promotions could not be effected, which resulted in their loss in seniority, which is in turn affected their future promotional prospects. In matters of promotion, with retrospective effect, it is settled law that the same cannot be resorted to except on very sound reasons and foundation. It becomes necessary to do so. There have been cases, no doubt, where retrospective promotion had been granted and approved by the courts, but the same were done on the consideration of special circumstances surrounding that particular case, such as by operation of certain rules. In the instant case, an As observed earlier, the only claim to retrospective date of appointment is due to non-sitting of DPC. No avoidance have been made that the scheduled DPC or DPCs had been cancelled or there were any malified intent in not convening the same. The only stand is that as per an advisory issued by the respondents in the year 1998, DPC were to sit on at regular intervals. This, however, has been countered by the respondents in the reply that as per notification of 4/9/2003, regular promotions should be effected from the date of officer takes charge after promotion orders have been issued on the basis of recommendation of DPC. The memorandum 4/9 of 2003 is reproduced. Then we'll kindly have para 10.
Yes.
Promotion to a higher post in the instant case is not a case of functional promotion, but as can be seen involves a process of selection and recommendation by a duly constituted DPC. A mere existence of vacancy, therefore, will not create a vested right for an eligible employee to claim for appointment and promotion to the said post, especially when the same has to be finalized through a selection process. A case that is relevant and has a bearing on the point in the issue wherein leading cases have been digested is the case of Union of India versus KL Taneja. In this judgment, decided by Delhi High Court on so-and-so. In this judgment, which has great persuasive value, after analyzing many cases on this point at para 21, it has been held as follows. Para 21. The cornucopia of case law above noted brings out the position. Number one, service jurisprudence does not recognize retrospective promotion, that is a promotion from a back date. Number two, if there exists a rule authorizing the executive to accord a promotion from the retrospective date, a decision to grant promotion from a retrospective date would be valid because of a power existing to do so. Number three, since malified taints any exercise of power or an act done requiring the person wronged to be placed in the position the person would find himself, but for the malified and the tainted exercise of power or the act, promotion from a retrospective date can be granted, my lord, it says. If delay in promotion is found attributable to a malified act that is deliberately delaying holding DPC, depriving eligible candidates the right to be promoted, causing prejudice. So this is my case, my lord. The part 3. Now part 11 also talks about another judgment, and then, my lord, the finding at page 12.
This mala fide has not been properly made out at all. Only thing is DPC has not been held.
Yes, my lord.
That's all.
Yes, my lord.
But where is the mala fide?
My lord, I am showing the mala fide for intentionally delaying.
Where have you shown that intention?
My lord, that is page 78, my lord.
Today there might be 100 posts vacant. The government may not have funds to pay for the promotional for the personnel in the promotional post.
Correct.
It will say, I will not fill it up for 2 or 3 years. I don't have the money.
Correct, my lord.
Or there is lack of duty to be given to the persons in the promotional post. The government says, I will not fill it up because there is not adequate work for them. Many factors may be there.
Correct.
Together with mala fide, as you say. But where is this case made out?
But that is why
Post was 4, ad hoc were 11
9.
or 9, plus 3 were regular after them. So if I try to fill up the post when they are not regular or ad hoc, 3 out of 4 will be taken away
Yes.
by 10 to 13 or whatever.
Yes.
Only 1 will be left for them.
Yes.
But if I keep it in abeyance, the selection process for a few years and wait for regularization by the government, I can give them 4 posts. Where is that case?
My lord, my case is that
DPC was not held. That is discussion.
DPC was not held because there was an intention to deprive us.
Where is that?
And favor.
Where is that made?
My lord, that is the DPC itself, my lord, page 76.
That is not there.
Recommendation.
DPC is not held, finished.
But it is recorded in the
Annual
DPC.
general meeting of a company not held, not held.
Yes, my lord.
Executive council's meeting of a university not held, not held.
Correct,
1 year,
my
2 years, 3
that
years.
is correct, my lord. But here it is very clear from the note placed before the DPC, my lord, and the DPC, that the DPC coming to a finding that giving a recommendation that they should be promoted retrospectively because of the delay, which was on account of the department waiting for regularization of certain employees, my lord, ad hoc employees. So it was deliberate to keep us out, my lord.
They had no business to say this. It is for the government. DPC has any business to say this?
Look, this is the note, my lord, which is placed by the government, by the department before the
Not right.
DPC.
DPC is a selection committee.
Yes, my lord.
Selection committee has got this power.
No, my lord.
Sure.
It is the department which has placed this note before the DPC. DPC only recommends
Yes.
on the basis of
Page
the
76 is the DPC's note.
76, the recommendation of the DPC, my lord, which recommends for retrospective promotion. And page 77 is the note which was placed by the department before the DPC.
Yes.
So, Lord, that is my submission, Lord. Very thin line, Lord.
May it please your lordship. Lordship, the reason why the DPC was not held, your lordship, that has been explained, your lordship, by the state in our affidavit, your lordship. The reason is that the office, your lordship, was caught by fire, your lordship. And their grievances, your lordship, were taken care by the DPC, your lordship, in the year 2019, your lordship. The DPC, your lordship, which sat in the year 2019, lordship, recommended the appel on your lordship with retrospective effect for promotion. But that has been turned down, your lordship, because of the reason. Lordship, kindly, if lordship kindly come to page. If lordship kindly come to page 59. Lordship, that letter dated 27, 2020, your lordship. We say, lordship, that because of the operation of the office memorandum 43/2003, that has not been considered by the government, and lordship will find that memorandum at page 60. So, your lordship, this memorandum, your lordship, speak clearly that no retrospective promotion will be given, your lordship. And this, your lordship, this memorandum, your lordship, was never called into question, Your Lordship, before the learned single judge, Your Lordship.
Yes.
Then, Your Lordship, the contention that because the DPC was not held, because a government is waiting for regularization of that, Your Lordship, that is not correct, Your Lordship. Because what happened again, this judgment, Your Lordship, a review has been filed, Your Lordship. If Lordship kindly come to page 92. This is the review application, Your Lordship. Lordship, I'll come straight away to page 139, Your Lordship. That is the order passed by the learned single judge, Your Lordship, whereby the contention of the writ petitioner, writ appellant, has been repelled. Lordship, kindly come to the page 139, Your Lordship. That means this is an application for review of the judgment. This is the order passed by the learned single judge. That is the order dated 18/5/2023, Your Lordship. Lordship, kindly come to page 41 at paragraph 5 or at the finding of the learned single judge. In the considered view of this court, though there may be certain inconsistencies as to the reason shown, the note appended at Annex of 5, that means that was that notes which has been shown before Your Lordship, that regarding those people whom they allege that the government is waiting for regularization, which is undated and the reason shown therein not supported by any other material. Further, the accreditation list of LDA clearly shows that the petitioner, that person senior to the petitioner, could not be considered prophet along with the petitioner. Lordship, kindly see, even the people who are senior to the writ appellant have not been considered, Your Lordship, for promotion, Your Lordship.
Which paragraph is this?
Lordship, kindly come to page 141.
Yes.
Lordship, kindly come to paragraph 5. That is the finding of the Honorable Single Judge, Your Lordship, in the review application filed by the writ appellant. In the considered view of this court, whether Lordship has gotten.
Where is the note appended to Annex 5?
Lordship, and that is
At page 77, my lord.
page 7.
Department's note placed before the DPC.
That you have shown already.
Lordship, yes. They are referring this undated note, Your Lordship, in the review application, Your Lordship. And the finding of the learned single judge is that, Your Lordship, the person, even the person senior to the writ appellant also have not been considered for promotion, Your Lordship. So, in my humble and respectful submission, Your Lordship, the prayer of the writ appellant, Your Lordship, for grant of retrospective promotion, Your Lordship, cannot be considered, is liable to be rejected, Your Lordship. And to that effect, Your Lordship, I would like to please a judgment of the Honorable Supreme
No,
Court.
we have considered all the judgments.
Lordship,
It is absolutely true, it's a policy matter.
Lordship,
If the government doesn't fill up the post, it is up to them.
I'm highly
If it does not feel that promotion should be effected, it might defer it for 2 years,
Lordship.
for whatever reason. Mala fide has to be shown. All right. Now, your own agency, your own department
Lord,
is explaining the delay
Lordship,
and is saying that because of the delay, give them retrospective effect. It completely turns the whole table.
Lordship, that is the
If you had not done so, you could have very well said that it is a policy matter, it is for us, we will fill it up whenever we feel like, what right you have. But you are yourself saying that they need retrospective effect. That means that some wrong has been done by the
No, Your
government.
Lordship, that was the recommendation of the DPC, Your Lordship.
DPC is part of the
But that
government.
has been torn down by the government, Your Lordship. That has been torn down by the government
No, DPC
because, Your Lordship, of the...
DPC is a committee of the government
It's
itself.
true, Your Lordship. It's true, Your Lordship. It is it's only a recommendation, Your Lordship. But the government did not accept because there was an office memorandum 2003 which says, Your Lordship, that no retrospective.
Because in the normal course,
Lordship.
there is no retrospective effect. But
Lordship.
yes, your own committee is saying give them notional effect.
That has been torn down, Your Lordship, by the government.
So
That
how
has been
could
torn down by the government, and they were given the promotion with effect from 2020, Your Lordship.
So they have made an admission that this delay ought to be compensated.
No,
Try
Your-
to think of it.
No, Your Lordship, there is no relief claim in the writ petition. There only is that you keep us a national promotion, Your Lordship.
Notional promotion what?
Retrospective promotion, Your Lordship.
Yes,
They are still in service, Your Lordship.
that is
They are still
compensation
in
what the
service,
government
Your
is
Lordship.
paying.
They are still in service, Your Lordship. They are
Up
not
to
retired,
today,
Your Lordship.
Nothing. But as of today, the pay will be recomputed from 2019 or whatever year they have chosen, 2014.
Lordship,
And on the recomputed pay for UDC, they will be paid from today. How many years of service left of your client?
But long service, my lord. We
they
still
have a
have,
law service,
we
Your
still have
Lordship.
time.
Lordship, this
We entered service in 2009, my lord.
a retrospective promotion, Your Lordship, in my humble and
Because it affects-
in my humble and respectful submission, Your Lordship, cannot be entertained, Your Lordship. In view of that notification of the government, Your Lordship, 2003, Your Lordship, which the writ appellant have not put to challenge, Your Lordship. If Lordship, I would like to,
No, you have shown me those judgments discussed by his lordship.
Lordship, another, this is also 2024 judgment of the Honorable Supreme Court, Your Lordship. If Lordship kindly come to para 19 of that judgment. It is a well-settled principle, para 19, Your Lordship, that promotion become effective from the date it is granted, rather than from the date a vacancy arises or a post is created. While the courts have recognized the right to be considered for promotion as not only a statutory right but also a fundamental, there is no fundamental right to the promotion itself. In this regard, we may carefully refer to the recent decision of this court in the case of Bihar State Electricity Board versus Dharam Dio Das, wherein it was observed as follows. It is no longer res integra that the promotion is effective from the date it is granted and not from the date when a vacancy occurs on the subject post or when the post itself is created. No doubt, a right to be considered for promotion has been treated by courts, not just as a statutory right, but as a fundamental right. At the same time, there is no fundamental right to promotion itself. Then, Lordship, kindly come to para 20. In the state of Bihar versus Akuri Sashindra Nan, it was held that retrospective seniority cannot be given to the employee from a date when he was not even born in the cadre, nor can seniority be given with retrospective effect as that might adversely affect others. The same view was reiterated in Keshav Chandra Joshi versus Union of India, where it was held that when a quota is provided for, then the seniority of the employee would be reckoned from the date when the vacancy arises in the quota and not from any anterior date of promotion or subsequent date. The said view was restated in Uttaranchal Forest Ranger Ashan Direct Recruit versus State of UP in the following words. We are Also of the view that no retrospective promotion or seniority can be granted from a date when an employee has not even borne in the cadre so as to adversely affect the direct recruit appointed validly in the meantime as directed, as decided by the school in case option so and so, held that when promotion is outside the quota would be returned from the date of the within the quota, rendering the previous service of the previous promotion would not be regular only from the date of the within the quota shall be counted and not from the date of the earlier promotion or in order to do justice, this court has constantly held that no respective promotion can be granted nor can seniority be given on retrospective basis from a date when the employee has not even borne in the cadre, particularly when this would have affect the who has been appointed validly in the then Lordship para 21, while concerned, we cannot respondent right to be considered for promotion, which is a fund under Article of India. He does not hold any absolute right to promotion itself. The legal precedent discussed above established that promotion only becomes effective upon the assumption of duties on the promotional post and not on the date of occurrence of the vacancy or the date of recommendation. So, Lordship, they have been given promotion in the year 2020. So, Your Lordship, that it will towards their future retail benefits, Your Lordship.
What is the next promotional post?
Lordship, super.
Or there is no,
Head assistant.
I think it does.
Head assistant.
when you're eligible for that?
Well, if we complete 5 years as UDA.
And if they have not given also, Your Lordship, that MCAP also they will be. That professional career scheme also they will be.
But for that also, there's a
Yes,
eligibility
there is
of
a-
12 years. So they also will miss out, my lord, because 5 years, Lord, we are missing.
So when has the effect been given? 2020.
My lord, 2020.
So you're in the 5th year now.
Yes, my lord. But because there are very few posts, my lord, of the higher post, so we will be getting benefits of, my lord, the ACPS scheme. So for that also, the counting is very important, my lord, number of years.
The next promotion you said is?
Head assistant, my lord.
All right. That's all?
Yes,
Lordship, that's all, Your Lordship.
You are not citing any cases?
no, my lord, I'm relying on those judgments cited by the exception in those judgments.
Another aspect also, Your Lordship, they allege malafide towards the government, but those people whom they allege malafide, they are not before Your Lordship.
Yes. Hearing concluded, CAV. You wish to file notes?
My lord, whatever your lordships,
Learned counsel for either party. That same format, huh? Before the master attached to this court by notes by 11th March.
11. Highly apply.
Chief.
You can call item number 3 till 13.
Yes.
May I begin, Your Lordship?
Uma Devi,
Lordship, yes.
this falls within the exception.
No, Your Lordship. No, Your Lordship, because they are, in my humble and respectful submission, Your Lordship, they are bound by the terms and conditions of the walk-in interview, Your Lordship. They took part in that walk-in interview, Your Lordship, willingly, voluntarily, knowing that the stipulation laid down therein, Your Lordship. If Lordship kindly come to page 63. Bold letter, Your Lordship, page 63. Lordship, this is the walk-in interview dated 10 November 2009, Your Lordship. Lordship, the walk-in interview, Your Lordship, stipulated. This is a special drive, Your Lordship, a special drive on temporary basis on condition that they qualify the appointment in a regular manner from the recruitment agencies, namely Meghalaya Public Service Commission, District Selection Committee, as per the detail below. So, Your Lordship, they willingly, voluntarily, Your Lordship, apply for this post, and they knowing fully the terms and conditions stipulated in the work interview, Your Lordship. A red petitioner respondent here in Your Lordship, they got through in this walk-in interview, Lordship, and they were appointed, Your Lordship, in the year 2010, Your Lordship, and their appointment, their model appointment, Your Lordship, is extendable 1 year and extendable by another year. Lordship, kindly come to page 68. Lordship, this is the model appointment. Model appointment, Your Lordship. The appointment is for a period of 4 years, Your Lordship. It says very specifically, Your Lordship, at the date of joining or till the post is filled up on regular basis, whichever is earlier, Your Lordship.
Wait.
Lordship, kindly come to page 68.
Advertisement.
No, Your Lordship, their appointment, Your Lordship. They are the first appointment, Your Lordship, which they took part, that is at page 63, Your Lordship. Kindly come to page 63, Your Lordship.
68. Then above.
May I pray, Your Lordship? I pray, Your Lordship, I'll make the date-wise, Your Lordship, then the notes, Your Lordship, then I'll hand over to Your Lordship on some other day, Your Lordship, for ready reference by Your Lordship, for it's easy for Your Lordship to.
No, here the advertisement says that appointee lady supervisors
Lordship, yes.
may apply.
Lordship, kindly come to P68.
No, this writ petitioner
Lordship.
is a lady supervisor.
Lordship, yes.
She applied.
She applied, Your Lordship. If Lordship, give me some time, Your Lordship, I'll make a note along with the
Which
all this, Your
means
Lordship.
that she took part in the regular selection process.
No, Your Lordship.
Then how did she apply?
No, this is only a temporary. Lordship, kindly come to P63.
Yes, you read because the pages
Lordship.
are not telling.
Yeah. Lordship,
Pages are not telling, so you read.
I'm sorry, Your Lordship.
No, you read, we will hear.
Lordship, it's like this. The Office of the Directorate of Social Welfare, this is a walk-in interview dated 10 November 2009. I'm sorry, Your Lordship.
No.
I'm sorry. I'm really sorry, Your Lordship. If you allow no. Lordship will do a proper paging, Your Lordship. I'm really sorry, Your Lordship, for the inconvenient caused to Your Lordship.
Yes. She did not apply.
No, she applied, Your Lordship.
So that is what we are saying, that
Lordship, yes.
if you have applied, you have taken part in the regular selection process. Now, can you claim regularization on the basis of ad hoc employment?
No, Your Lordship.
That is what I was trying to ask.
Lordship, I'm highly obliged, Your Lordship. I couldn't.
Because by taking part in the selection process, you can be said to have given up your right for, what do you say?
Yes, madam. Selection process was subject to that interview. But our only problem was that the interview never took place in last 14 years. Had they advertised the post, I would have taken part in the.
No, it was advertised, Your Lordship.
But
It was advertised, Your Lordship. But in 2015, Your Lordship.
You have taken somebody, you have filled up the post of stenographer,
No, Your Lordship, they are still in service. They are still in service, Your Lordship.
vacant.
Lordship?
The selection process is over.
no, my lord.
No, Your Lordship.
It was not there.
On the basis of this, Your Lordship, on the basis of this walk-in interview in the year 2009, Your Lordship, they took part, Your Lordship. Then in 2015, Your Lordship, there was a request made for regularization. That has been turned down by the government. So also in the year 2018, also, Your Lordship, there was another request for regularization of the service. That also has been turned down by the government, advising them to take part in the.
But how could we take part when there is no advertisement? 2 advertisements were made and they were kept in abeyance.
In the open competition, Your Lordship. Then again in 2003, in 2023 also, Your Lordship, a request was made for regularization. That also has been turned down by the government. We are supposed to advertise the post, Your Lordship, and they came by filing a writ petition.
But 14 years lapsed in the meantime and no advertisement took place. 2 attempts were made to advertise and that was kept in abeyance by the government. So where could we go? And that is why the single judge says that let there be a fresh interview. We are ready to appear in that.
Because they will have to undergo, Your Lordship, in open competition, Your Lordship. Because the condition of their appointment.
Stenographer is only one post.
No, Your Lordship, they are all. At the time, a number of posts are there, Your Lordship. Number of posts, Your Lordship, are there. Because all of them,
There are the 11 candidates who pass in the interview are before Your Lordship. They are the ICDS, Integrated Child Development Scheme. And they joined the services and they were given to understand that there will be interview, you take part in the interview. But no interview took place in 14 years.
allowed us, we will advertise, will cause advertisement of the post held by the writ petitioner. They are at liberty, Your Lordship.
My lord, after 14 years, what is my position? We will not be able to compete with the newcomers, my lord.
Sorry?
Now the age problem will be there for these petitions, my lord. And second, it will be the newcomers, freshers. How can they sit for interview and they will be the irregular position?
We will also consider the question of any damages.
My lord, if Your Lordship come to page 151, that is the last page of the paper book, my lord. What the learned single judge has said. (151). Paragraph number 11, my lord.
Page?
Page 100, last page, that is 151, my lord.
That order of the court?
Yes, my lord.
Yes.
It is in the last paragraph, my lord, 1 to 3, line number 3 from the bottom, my lord. The state respondents are liable to be directed to conduct a special interview or examination to enable the writ petitions to be considered for organization thereafter. We are ready for interview. There is no problem for us. For last 14 years, we have been waiting for the interview to be taken, to be advertised, my lord. And now at this stage, my lord, when all of our thing age bar is there, then Lordship will, if it is, they should be the open candidate, then what will happen with this 40 years of the experience?
Lordship will
We are
allow
not at
us
fault, my lord.
to
We are
cause
not at fault.
advertisement of the posts. Then they are at liberty to take part. So far, the age relaxation, that will be considered, Your
My
Lordship.
lord, another thing is that they have taken a special interview only for 3 candidates.
What is the age, what is the relaxation now involved?
Lordship, so for the tribal, Your Lordship, it's up to 37.
36,
37.
My lord, they have taken a special interview on 3 occasions.
37.
Only to 3 candidates, my lord. Why we were not considered at that time? Suddenly, one fine morning, 3 persons were called, interview taken, they were declared pass, and in last 14 years we are suffering.
And what is the age limit?
The age limit is 37, Your Lordship.
You are 37. How old are you?
We are 39, my lord.
37.
Age limit 37.
Yes.
Your client is how old?
My lord, here the position is that from 1 to 11, respondents here, my lord, it is 40 years, 46 years, 38 years, 46 years, 44 years, 39 years, 42 years, 38 years, 41 years, 40 years, 43. This is their age. Now if they are to sit in the opening interview, what will happen to them? We are ready to sit for the special interview as they did with other 3 candidates, my lord.
Lordship will
3
make,
candidates were selected for a special interview.
will make an observation that when they apply, Your Lordship, so far,
You are willing to undergo the selection process.
Yes, my lord, we are ready to.
You?
Lordship, yes, it should be open, Your
But
Lordship.
it should be, why it should be open? It should be special, my lord.
It should be open. So far, each bar is concerned, Your Lordship. Lordship will make an observation that the authority will take a decision, Your Lordship, to relax their.
No, this is not the problem, my lord. This is not the issue here. Issue here, why they did select only 3 persons for a special interview. At that time, we were not included in that interview. Had we been given the chance to take part at that point of time, we would have been selected. Other three are selected and they're enjoying their salary and their increment, everything, and have lost everything, all financial things. And suddenly I am to sit in an open interview. Is not it injustice to me or not?
Lordship, because their initial appointment, their initial participation in the walk-in interview is very clear, Your Lordship.
It is clear. I agree it is clear, my Lord, that why it was not taken.
Very clear, Your Lordship.
Why for 14 years they had to wait for that? And in the meantime, we have undergone several trainings also in the departments. And once it is an open interview, then we are gone. We will be thrown out. Interview, we are ready, my Lord. But not the way my learned friend is suggesting. Had they taken the initial stage in the first year or second year or third year, that would be a separate issue. But after 14, 15 years, they are asked to go for open interview with all.
Then what will happen? For 14, 15 years, what?
No interview taken. Twice it was advertised and twice it
They
was.
are quite young, not that they have become aged and senile.
So whatever the case might be, they will have to sit with so many candidates. What will happen to them for the last 14 years? Their experience will go. They have already suffered incurred loss in comparison to those three candidates who were asked to come for
They were
special
employed
interview.
on an ad hoc basis.
They were appointed, yes, that is not disputed. Then why is only three were selected for interview at that time? Had we been also given the chance to sit in the interview, then whatever happened, happened. But they selected three and they're enjoying their salary and increment and we are suffering. And now it comes that then let me open an interview after 14 years, my Lord. They have themselves created this discrimination, my Lord, by selecting three and leaving us alone here.
You are still working.
Yes,
Still working, Your Lordship, yes.
And those three who were appointed with us, they are enjoying their increment and financial benefits, my Lord. I have lost that benefit also, and now I am to sit interview. Where I fail, then I am thrown out. Had they taken that interview along with the three, then we would be in better position. They are answerable for the delay of this 14 years, my Lord. They are answerable for the discrimination they created for three only, not for us. And that is why the learned single judge has said that let there be a special interview for them. Of course, in that special interview, they cannot compete, that is another thing. Because they are not, the respondents are not at all at fault, my Lord. They have ever been ready to sit for interview. Whenever they said we are going to take part, it was kept in abeyance. 3 times it was kept in abeyance, my Lord. And so far the Uma Devi case is concerned, my Lord.
And after representation, Your Lordship.
My Lord, after Uma Devi case, what I mean, Uma Devi, they have created 2 sets. One is irregular entry and another is illegal entry. We are neither fit in the illegal nor irregular. It was a cabinet decision, my Lord, then only this interview took place. And we took part in the interview, in the walk-in interview. And the interview was taken by a departmental committee, my Lord, consisting of the commissioners and directors and all the big bosses, my Lord. Out of 100 candidates, we passed. And now second interview we have to face again open. So we are not at fault that it was interview, it was advertised and I did not take part. We were ready to take part in the interview. And after 14 years, they said that let there be interview now. That is why learned single judge, it is a special case. And Uma Devi case is not at all applicable here, my Lord. That a cabinet nod was there, cabinet decision was there, there is no backdoor entry. And we are taking the tag of ad hoc employee till date after 14 years without any fault. And recently the Uma Devi case in 2024, twice it was re-examined, my Lord. And the Supreme Court has said that it is well established that the decision of Uma Devi does not intend to penalize employees who have rendered long years of service, fulfilling ongoing and necessary functions of the state or its instrumentalities. The said judgment sought to prevent backdoor entries and illegal appointment that circumvent constitutional requirement. However, where appointments were not illegal but possibly irregular, and where employees had served continuously against the backdrop of sanctioned functions for a considerable period, the need for a fair and humane resolution becomes paramount. Prolonged, continuous, and unbelievable service performing tasks inherently required on a regular basis can over the time transform what was initially ad hoc or temporary into a scenario demanding fair regularization. In a recent judgment of this court in Vinod Kumar and other versus Union of India, it was held that procedural formalities cannot be used to deny regularization of service to an employee whose appointment was termed temporary but has performed the same duties. This judgment, the recent one, there is the December 2024. And it has that it is the misuse of temporary label on the employees.
1 minute. Is it judgment?
But I was reading at paragraph 20. I was reading from paragraph 20, page number 19.
So this is the only case you are citing.
Yes, ma'am.
You are not citing any case.
Lordship,
I'm citing another case, my lord.
All the cases referred to in the judgment of His Lordship.
I'm citing two cases, my lord.
Some cases have been referred. No, sir.
My lord, I'm citing two cases.
No.
My lord, the judgment of Vinod Kumar is also discussed in the next Jago case. This now the Jago case, Jago versus State of India is the main citation I will make, my lord.
Okay. That's all.
Lordship, I'm citing also some judgment, Your Lordship.
Again, what is this? How long this will go on? What are you citing? Please do.
Lordship, I'm citing Uma Devi judgment, Your Lordship. Para 47, Your Lordship. Para 47. And then another judgment, Your Lordship, passed by this Honorable Court, Your Lordship, that is at page 50, Your Lordship. Felicia
This is
Khonglam,
unreported.
not reported.
This is a note you have prepared.
Your Lordship, yes.
Yes, Uma Devi, yes, then.
Then Felicia Khonglam, Your Lordship, at page 50, 55, similarly situated with this case, Your Lordship. And then another case, Sulaiman Sarkar versus State of Meghalaya, page 56, 62,
What
Your
is
Lordship.
the proposition?
The proposition, Your Lordship, kindly come to page.
Don't take ad hoc, take regular appointment. If absolutely necessary, take ad hoc, but then keep them till the regular appointment is made. That's all. This is the proposition.
Lordship, yes.
And if there is long continuous service and without break, etc., then think of regularization
But in this case,
in a very exceptional cases.
but in this case, Your Lordship, because as I have submitted earlier, Your Lordship, that there was a break, Your Lordship.
No break was the
Some,
matter continuous.
they were terminated,
No,
Lordship.
I'm sorry, it is not the case. We are continuously
They
serving.
were terminated, then Lordship taken back, like that, Your
That
Lordship.
is why my lord, this
There is a
judgment
break,
of
Your Lordship.
Supreme
It's
Court
not
of December
continuous, Your
24,
Lordship.
this judgment of 24, my lord, in the Jago case, it clearly says this thing, discuss these matters on the Uma Devi case. It has revisited Uma Devi.
Page number 54.
They were terminated, then taken back, Your Lordship.
No, never terminated.
For example, Your Lordship, kindly come to page 54 of the memo of appeal.
Yes.
It's not that they were in continuous service, Your Lordship. They were terminated, then taken back, Your Lordship. Like that, Your Lordship. The nature of appointment.
No, it is not like that. I dispute this part, my lord. We have been continuously serving this without break.
That's all, Your Lordship.
Same. Written
Highly obliged, Your Lordship.
by whatever date given, same date as the earlier matter, same one. These are all separate appeals.
Your Lordship, it's again the common judgment. Same,
So one judgment may be delivered.
Your Lordship, yes.
The case of all the
Similarly situated, Your Lordship.
We need to